25 minutes before 11 o'clock. Thank you for tuning in. It's time for Legally Yours. This is your best opportunity to get some questions answered about your legal circumstances if you are in any. Maybe it's Social Security, maybe you were in an accident, maybe you know somebody going through a divorce, or maybe you are. John Fuller is here to answer those questions. He's an attorney at the law firm of Fuller & Fuller here in Ocala. The phone number to call is the WOCA Climate Control Source Hotline, which is 622-9622. I see some people looking online, so if you're out of the area code is 352. So 352-622-9622. Good morning, John. How are you?
Good morning, Larry. It's great to be here, and good morning to our listeners, and hope everybody's having a good summer so far. And it's nice to be here. If we have questions from folks who are listening, please call in. We talk in rather general terms because so many cases are specific. If something has just happened to you or a family member or a loved one or a friend, such as an automobile accident or trip and fall or other type of injury case with serious injuries, we'd be happy at Fuller & Fuller to talk with you about your injury cases. We handle accident cases, and there are a number of important things. We've talked about it before. If you are in an accident, don't make statements to the adverse party or his insurance company without consulting with a lawyer for yourself. Don't sign anything. Be sure that you immediately seek medical treatment within 14 days. Those are all things that that can have dramatic effect upon your rights, and it's very important that you do that. We also handle Social Security disability claims. That's my wife and partner Janet Fuller's area of focus in her practice. Janet was a former registered nurse at Shands Teaching Hospital in Gainesville for 7 years and went to University of Florida and got her law degree.
Oh, wow.
For many years now, she has focused her practice exclusively in Social Security disability cases. So if folks have questions in that area of the law, certainly call our office. The Ocala number is 352-547-4292. We have a toll-free number, 855-734-2565. I mentioned that because we get a lot of questions on the show that I dearly love talking with our listeners. We have some very sophisticated, knowledgeable, informed listeners, and it's a delight for me to be able to come in and talk about our legal system, our judicial system. It's a system that I respect and admire and have been privileged to work in for over 40 years. But we talk in general terms on a call-in radio station, and many cases all cases are fact dependent. And if you have a case, you need to hire or consult with a lawyer. And we at Fuller & Fuller would certainly be happy to sit down and talk about your case individually. If there is a case that has interesting comments or interesting features to comment on, I meant to say, that are in the news, that reveal certain aspects of the judicial system, that we're able then to maybe enlighten some folks on how the system works, then that's an important part of this show too. So either way, we invite your calls. We enjoy this opportunity to talk to our listeners and of course talk to you, Larry, about the legal system in general, but we certainly encourage folks who may have suffered a serious accident to seek legal counsel, and if you are interested and care to, we'll be happy to talk with you. In the area of family law, we do a limited, specialized type, focused type practice of cases involving significant complex issues, substantial assets, major contested matters, and if that's the type of case that you have based upon the type of assets you have, whether it's a business or a professional association, something like that, then those are the areas that we focus in. We work with a lot of very talented experts to support us in that endeavor, and we would be pleased to talk with you. Those are very emotionally difficult times and difficult things for folks to go through, but a lot of people do find themselves in that situation, and we certainly would be happy to talk with you about something like that. So that's a little bit about background. We've been doing this show about 2 years, I guess.
Yeah.
It is a delight and continues to be a delight.
Yeah. The phone number is 622-9622. I neglected to mention the date so that you know you're listening to a live show or not. It's July 30th, 2014. Let's take a phone call here. Good morning. Thank you for calling. You're on the air with John Fuller.
Good morning, John.
Good morning, sir. How are you?
All right, this is Mike.
Hello, Mike. I appreciate you calling.
The 14-day rule, is there a written rule that medical conditions will only show up sometime within a 14-day period?
Well, that's a good question.
For some reason, you get in an accident and you are treated at the scene and there's no apparent reason to go to medical treatment or whatever. What is the alternative if something shows up after that 14-day period?
Well,
what would be the alternative to that? I will hang up and listen to your answer.
The 14-day rule that we talk about applies to your entitlement to your full personal injury protection benefits. That's the insurance that you buy, that you pay for, that until year before last, when the governor got a law through the legislature on the last day of the legislature that said that even though you bought and paid for $10,000 of personal injury protection coverage, that if you were not seen and treated by a medical doctor, an osteopathic physician, a nurse's advanced registered nurse practitioner, or a physician's assistant, within 14 days, you would lose the bulk of that $10,000 to cover your medical bills. So it is important, because as you pointed out, Mike, and you are so accurate, they are medical injuries that the medical profession refers to as emergent injuries, which are injuries that do not show symptoms or manifest themselves immediately after the event of trauma, the accident, but are late developing. So it's important that you go to a doctor. Unfortunately, this law was passed to eliminate chiropractors, naturopaths, massage therapists, other people. If you go to them, their opinion won't count. You need to go to one of the 4 specialties that I mentioned, or one of the 4 medical areas, and get an examination. And have that on your record, that it was documented, what the injuries were, so that even if it shows up at a later date, they can relate that back to a significant medical event, and you would have a claim for the full $10,000. If you don't go, then you forfeit the majority of that $10,000, even though you've paid premiums for it. That law is being challenged in the courts as unconstitutionally depriving citizens of their access to the courts. The legislature can do that. They did it in the early 70s with the no-fault insurance, where they said you cannot sue the person who is at fault for causing the accident unless you suffer a permanent impairment, loss of a limb, significant scarring or disfigurement, or death. and you have to allege and prove that before you could file a lawsuit against the person who caused the accident, who was at fault, who was negligent. And when they took away that right, they balanced that, which the court said was satisfactory with the public interest, by providing that you would have a $10,000 fund that would immediately pay 80% of your medical bills and 60% of your lost wages without any delay, regardless of whose fault the accident was. And that benefit that you were entitled to was a reasonable trade-off for keeping small cases out of the court system and trade-off for your right to file the lawsuit. You still had it. Now they've taken away your right to sue the person who hurt you, and they've also taken away the majority of your PIP coverage if you don't get medical attention that certifies it as a significant medical event within 14 days of the injury. So all I can tell you is that if you're in an automobile accident and you go to the emergency room and they treat you and release you, almost every discharge summary I've ever seen would be to follow up with your primary care physician or to return if you have any further symptoms, and you most certainly need to go to a medical doctor, an osteopathic physician, that's a DO, a doctor of osteopathy, a physician's assistant, or an advanced registered nurse practitioner. You need to see one of those four people within 14 days so they can examine you, order necessary tests as they see fit, start treating you, have you return for follow-up visits, and then if something does show up, it's related back to that 14-day period, and you have preserved your claim for the full $10,000.
Yeah, and that is a crazy law that you explained really well before, and hearing it again, it's like, how did they ever decide that stuff? We need to take a 30-second break for the weather, and we'll be right back. If you have a question for John, please call right now. The number is 622-WOCA. We'll be right back.
The weather is brought to you by myfwc.com. Safe boating is no accident. For today, intervals of cloud and sunshine and a little bit less humid this afternoon, the high 91 to 95. Partly cloudy tonight with a shower or thunderstorm near the coast early tonight. Low 69 and a few inland spots, 76 on the beaches. For tomorrow, sunshine, some clouds. Watch out for a thunderstorm in the afternoon and evening, the high 90 to 94. And on Friday, partly sunny with an afternoon thunderstorm, high 88 to 92. From the Florida Weather Center, I'm meteorologist Joe Lundberg.
All right, thank you. Let's return now to John Fuller and Legally Yours. And remember, if you have a question for John, the number is 352-622-9622. And today's date is July 30th, 2014, almost to the end of the month.
I know. It's hard to imagine. It seems like just a blink of an eye. It was we were starting this show 2 years ago,
right,
for the very first time, and I wondered then, my gosh, how will we ever fill up a 30-minute time slot with something to talk about? And I wanted to credit many of our listeners, some of whom are regulars. I recognize their voices. They are up to the minute on what's going on in the news that involve the judicial system, and it has made this program fly by.
I want listeners to call, so I say that so that when I ask a question right now, I want you to interrupt me and or John, because it might not be that important as yours is. Your question might be more important. But there was a question that we had this morning, and so we wanted to ask you. If somebody is arrested for having droopy drawers, and they go to you to be represented, and you win, on the basis that it's unconstitutional to have the law in the first place, would that be the end of that law? Would the law then be
the way that those things are ultimately determined? If there is a law that is passed and it is challenged on constitutional grounds, and the court dismisses the case on the grounds that the law is unconstitutional or unconstitutionally applied in that case, then the appellate process starts. And the appeal involving constitutional issues would ultimately be decided by the Florida Supreme Court. So if the prosecutor who is charged with the duty of enforcing laws files the lawsuit and it is declared unconstitutional, and the prosecutor refers it then to the Attorney General's office and they file an appeal, then it is ultimately determined by the Supreme Court of Florida. Down in South Florida recently, there have been some judges who have ruled that the ban on gay marriages was unconstitutional.
Right.
He made the ruling and then immediately entered a stay, which means that this is my ruling, but it won't be applied by anybody until it's had an opportunity to go through the appeals process. So they will often do that. I had one issue in my career that was of some local significance. Marion County had a noise ordinance. And my client was a large industrial company, and was where the neighbors were complaining that their operation violated the noise ordinance of Marion County. And I had a county commissioner who was serving at that time who was very proactive, and he took it on as one of his issues. And so they had a complaint made. A deputy sheriff went out to the scene with a very rudimentary noise meter and arrested our company executive and charged the company with violating the Marion County noise ordinance. The Marion County noise ordinance was ultimately ruled to be, our defense was this law is unconstitutionally vague. It can't be applied. The manner in which you are supposed to measure the decibels makes no sense according to the audiology principles. I had a wonderful PhD expert witness from the University of Central Florida who came up and set up sound monitors. And on Easter Sunday morning, the sound of birds chirping registered an amount of noise on the noise meters,
right,
which were highly sophisticated and calibrated, that the morning chirping of birds violated the Marion County noise ordinance. We then went to court. The judge was Judge Edward Stevens, who was a very excellent county court judge who's retired now, and we had the case. And I had also a constitutional lawyer who was going to testify as an expert, plus this PhD who had done all the studies and set up and measured our plant and operation, and then measured the things. Easter Sunday morning, it just happened to work out that way. And the Marion County ordinance was ultimately, there was a stipulation that it was unconstitutional as applied, and ultimately Marion County ended up hiring my expert to help them draft a law that made sense, that would be fair to the citizens and could be fairly applied where there were legitimate violations without wrongfully charging innocent folks like mine had been.
Oh, wow. And you do have a phone call. Good morning. You're on the air with John Fuller.
Yes, good morning, Mr. Fuller.
Good morning, sir. How you do?
Very good, thanks. If in the state of Florida here, if you have income property renters, can you be liable for smoke detectors that are not functioning correctly without your knowledge?
I'm sorry, I didn't understand the question. Could you repeat?
If you have a rental property, and if you got smoke detectors in the building, and as far as you're aware of their functioning, but let's say all of a sudden they don't function anymore, in case there's a problem with maybe a possible death or whatever, would you be liable for that situation?
Well, I don't mean to waffle on you, but you could be. The tenant and the landlord can both have certain legal liability in the event the landlord maintains a premises that is in some way negligently maintained and does not meet certain code requirements. I'll give you, for instance, a landlord owned an apartment that was a garage type apartment, and you got to it up a series of stairs. and someone tripped and fell down the stairs and was injured. The lawyer representing the injured party had someone who was a specialist in building construction, measured the stairs and determined that they had been constructed in violation of the building code. There wasn't sufficient distance in the risers as required by the code, and therefore they were inherently dangerous, was his argument. And so they sued not only the tenant who had invited the people over for dinner who fell down the stairs for negligent failing to warn, they sued the landlord for negligently constructing and maintaining the stairway on it. So to answer your question, can somebody be potentially liable? The answer would, of course, have to be yes. Would he be liable in the factual scenario that you gave me? I would not be able to give you a definitive answer on, because there's a lot more factual issues that would need to be looked at. And I've not researched the ordinances, the building code, the building standards, the Southern Standard Building Code. I mean, those are things that you just don't deal with every day. And you have to remember that folks that call in with these really nice, interesting questions, a lot of questions don't get answered by the law because litigation is an expensive process. And the way legal questions sometimes are answered, most times are answered, is when when there's a case in controversy and it goes before a judge and there's a ruling and then there's an appeal. And that costs a lot of money.
Yeah, right.
And if people don't have significant damages, the cost effectiveness of doing that just to get a polite answer from the court never happens.
Yeah. You have another phone call.
Very good.
Good morning. You're on the air with John Fuller.
Good morning. I have a comment and perhaps a question, too. I don't know if you've covered this yet this morning. I have been going about, but the law on these guys wearing their trousers too low, is that possible that they could arrest somebody like that and charge them? I can't understand that unless they get the women along with it, because the women don't even have the underwear to cover themselves up. They're showing everything. Showing everything, top, bottom, in between. How can they possibly pass a law like that?
I'm sorry. You'll have to. I don't know whether it's my microphone, my headphones this morning, or what. But I did not understand what the initial question was, ma'am. Could you kind of repeat that?
How can they pass a law and not allow these guys to wear their trousers low when they're not showing skin? Women show skin.
Oh.
Top, bottom, all in between. How can they pass a law like that? The men that do that could really come against all this deal where they let the women go out on the streets like that.
Yeah, I understand. I understand. Your observation and complaint is that it's a violation of equal protection to have a law that prohibits the public wearing of clothes on males that drops down and displays their buttocks, and not have a corresponding law. I'm sorry?
They don't show skin. Women show all their skin.
Yeah, I understand your.
They show their shorts.
I understand your point, and it's an interesting question of balancing. And there's other interesting points in that law versus freedom of expression versus public protection of the health, welfare, and so forth of society. Those are thorny issues, and I don't know how it'll play out.
I imagine one of these days you'll get a client, though, that it'll become important. John, we are about less than a minute away, so real quick, how do we get a hold of you?
Okay, our office in Ocala, the number is 352-547-4292. Our toll-free number is 855-534-2565. Thank you, Larry, and thank you to our callers today.
And sometimes it's just like we've wrapped it up and I want to hear more because it was such an interesting show. All right, we'll take a little break and we'll be right back.
Broadcasting from the Paddock Mall Studios, this is WOCA, Ocala, Gainesville, The Villages, 1370 AM, 96.3 FM, The Source.